Today, we're tackling something really tough. It's this delicate balance the child welfare system has to strike. How do you step in to protect a child from harm without that very protection becoming a whole new kind of trauma? We're going to get into this by looking at one family's story as it unfolded in the courts. So, to really get this, we have to start with a key idea: adverse childhood experiences, or what people call ACEs. Look, these aren't just your typical bad days. We're talking about really stressful, traumatic stuff, like abuse, neglect, or losing a parent, that can just completely overwhelm a kid's ability to cope. And when a child is going through that kind of chronic stress, it can literally mess with how their brain develops. This isn't just about learning. It can affect everything from their impulse control to how they see themselves, and even their ability to connect with people. It causes real, lasting damage. And understanding that deep impact of trauma is so important. Because preventing it, that's the entire reason the child protective system exists in the first place. So, let's take a quick look at how the system is supposed to work. Yeah, on paper, it seems pretty simple, right? It's basically a three-step process. First, someone, a neighbor, a teacher, anyone, suspects the child might be in danger, and they make a report. Step 2, Child Protective Services, or CPS, comes in to investigate and figure out if the child is actually safe. And finally, Step 3, the agency makes a call. They either say the claim is substantiated, meaning, yep, they found evidence of harm, or it's unsubstantiated, which means they didn't find enough proof to back up the report, even if they still have some concerns. But this is where it gets really tricky. The goal is safety, of course, but the investigation itself, the court dates, the constant supervision, all of that can become this incredibly stressful, traumatic experience for the whole family. So what happens when the very thing meant to help ends up feeling like part of the problem? To really unpack this conflict, we're going to zero in on one specific case out of North Carolina. It's officially known as In Re MB. And trust me, it's a powerful example of just how messy these situations can get. And I want to be clear, this isn't just some abstract story. What you're looking at on your screen is an actual court document from this case. It involves a mother, Kelly O'Neill, and her daughter, Maura Bridges, from Union County. This piece of paper is the order that officially declares Maura as neglected and dependent. That's the legal trigger that puts a child under the court's protection. Okay, so to get our bearings, let's just run through a quick timeline of what happened. It all kicks off in November 2023 when the Department of Social Services, that's DSS, files a petition. By February, the court has stepped in and Maura is officially under its jurisdiction. Then, over the next few months, you see the court moving toward placing Maura with her father. This all leads to a final permanency plan and, well, an appeal from the mother. The whole thing unfolded over the course of about a year, but it moved fast. Okay, now we're going to get into the nitty-gritty, because at the absolute core of this case are two completely different versions of reality, and this is where things get incredibly complicated. So let's start with the father's role. According to the mother, Kelly O'Neill, he was basically absent, had a history of substance abuse and domestic violence, and was just using the system to his advantage. But then you look at the official records from DSS and the court, and it's like a different planet. They say he did everything asked of him, all the classes, all the assessments. They concluded he didn't need any more services and was a perfectly appropriate placement for his daughter. I mean, it is a complete and total contradiction. Can you imagine being the judge trying to figure out what's real here? And this conflict wasn't just about the father, it was also about the mother's actions. The court laid down some really strict rules for her. Absolutely no contact with her daughter for a time, and she was forbidden from posting anything about the case on social media. But according to DSS testimony, Ms. O'Neill did pretty much the exact opposite. They claim she admitted on a Facebook Live that she was watching the father's apartment, that she recorded her daughter at school, and that she sent some very derogatory texts to the DSS staff. And this tension really boiled over during the supervised visits. Social workers who were there documented that Miss O'Neill seemed really agitated and frustrated. They said she would interrogate her daughter and even recorded one of the visits when she was told not to. It got so bad that one visit had to be cut short after she allegedly screamed at Maura that their lives were in danger. You can see how, from the system's point of view, these were setting off some major red flags. So pretty quickly, this case ballooned from just a family dispute into something much bigger. It became a fight over fundamental constitutional and civil rights, with the mother arguing that the system itself was actually breaking the law. And a huge piece of this was the court's use of a gag order. It's a term you hear a lot, but what is it, really?
Simply put, it's when a judge orders someone involved in a case that they are not allowed to talk about it in public. And in this situation, it specifically told Ms. O'Neill she couldn't post a single thing about the case on any social media platform.
And this quote, which comes directly from the mother's appeal, really shows you how serious this was. Her lawyers called the gag order, and I quote, the most serious and least tolerable infringement on First Amendment rights. I mean, their whole argument is that telling a citizen they can't speak is an extreme step, and the government better have an incredibly good reason for doing it.
But her legal challenges went even deeper than the gag order. In a whole separate civil rights complaint, Ms. O'Neill laid out what she saw as a pattern of systemic failures. She argued DSS violated the Americans with Disabilities Act, or ADA, by discriminating against her because of her mental health without offering any accommodations. She also claimed her due process rights were trampled, that she was basically pressured into signing agreements and that the agency deliberately isolated her. And finally, she argued DSS failed in its legal duty to make reasonable efforts to help her family, instead just using these coercive safety plans.
So you've got all these conflicting stories, all these legal battles. How on earth does a court make a decision? Well, it all has to boil down to one single guiding principle. What is in the best interest of the child?
But in the middle of all this noise from the adults, what was the child, Mara, actually saying? Her voice does come through in the court records, and it's tough to hear. She reportedly told her guardian ad litem, that's the advocate appointed by the court just for her, that her mother used her as a therapist and that she was done with her. Just a heartbreaking thing for a kid caught in the middle to say.
So, after weighing everything, the two wildly different stories, the alleged behaviors, and of course, the child's own words, the trial court made its call. It granted sole legal and physical custody to the father, Michael Bridges, finding that this was the best path forward for Maura. So, a decision was made in this case, but the story really doesn't end there. It forces us to ask a bigger question. Is this just one incredibly difficult, complicated case? Or does it maybe point to some deeper issues within the child welfare system as a whole?
Well, think about this number for a second. 28%. It comes from a recent federal review of North Carolina's entire child welfare system. So what does 28% mean? It means that fewer than 1 in 3 kids who enter foster care in the state actually finds a permanent home, whether that's going back to their parents, being adopted, or placed with a guardian, within the time frame the federal government recommends. What that suggests is that all across the state, a lot of kids are just sitting in limbo, waiting for some kind of stability. So the long, painful road that the Bridges family went down, it might not be such an outlier after all.
And that brings us right back to the central, massive question we started with. It's the fundamental challenge for anyone working in child welfare. When a family is in crisis and you have to step in to keep a child safe, how do you do that without the system itself becoming another traumatic experience? How do you avoid leaving kids and families feeling even more broken than when you started? It's a question, and there are just no easy answers.